Good afternoon, my name is Sarah Rogers, and for those of you that don't know me, I'm a Senior Associate Solicitor and the Head of Housing Management within the Housing Litigation Department for Forbes Solicitors. So I thought today that I would talk to you about notices to quit. I get queries about these more than anything else from my clients. So I just thought it would be useful for me to go through the form of them, how, give you a general overview of how they're supposed to be worded, what they're supposed to look like. Then I thought we'd talk about notices to quit in relation to death, following the death of a tenant. And then I wanted to talk to you about tenant notices to quit and the form and content of those, and also how to deal with serving notices to quit when somebody appears to have abandoned. And then I've had a couple of questions already, so I've put them at the end, but obviously if anybody has any other questions as we go, if you just ask them, there's a way to do that. There's like a Q&A button that hopefully you can all press and you can ask me questions. And then at the end of the session, I will go through as many questions as I can and try and answer them for you. So, notices to quit. So the first thing that you need to know is that a notice to quit needs to be 4 weeks. It needs to give 4 weeks notice, and it needs to be in writing. It can't be given verbally. In addition to being 4 weeks, it must end on the last day of a period of the tenancy. So if we served a notice to quit today, that would be Tuesday, the 6th of October. It would hopefully be deemed served on the 8th of October. So it would need to expire 4 weeks on a Sunday, which would be the 8th of November. Sunday, the 8th of November. So in addition to those two things, that it must be 4 weeks and in writing, and just to say you can't accept it verbally, and you can't accept it verbally and then accept it in writing at a later date. Some clients do use email or web-based terminations. That is possible, but it is very tricky. So if you haven't set it up yet and you wanted to, I would recommend that you get legal advice. Obviously, some of the pitfalls will include the fact that people might be able to say that they are the tenant when they're not and terminate the tenancy on their behalf. So a tenant notice to quit needs to be 4 weeks in writing and be given in accordance with the terms of the tenancy. It's always worth looking at the terms of the tenancy agreement, because that might say something else entirely about the way in which a notice to quit is to be prepared and served. But if you are also, if you are serving the notice to quit yourself, if you're serving a landlord notice to quit, then the notice to quit also has to contain what's called prescribed information. And I'll come on to talk a bit more about that in a moment. But I did also want to talk to you about the fact that when I say that a notice, if posted today, will probably be deemed served on the second day after posting, that's just a rule of thumb really, and it doesn't actually apply to notices to quit. And the time of a notice to quit, the time should start running from the date that it's actually received. And obviously sometimes that can be quite tricky and difficult, especially if the tenant has gone missing, you're not sure where they are. Which is why, in addition to serving the notice to quit at the property, it's also very important to do everything you can conceivably think of to bring the notice to quit to the attention of the tenant or the occupier. So if you have an email address for them, you should email it to them. If you have an alternative address, you could send it there. If you have a telephone number, can you text them a photograph of the notice to quit? Wherever you can think of in terms of bringing it to their attention, the better. But obviously it does need to be served at the property as well in order for you to rely upon it. I have put PEA 1977 up there, and just to say that relates to the Protection from Eviction Act for those that want to know. And it's that act which specifies how a notice should be provided. So I said I'd come on to talk about the prescribed information. One of the beauties of doing this way is I can see these slides pretty clearly, and hopefully you guys can as well. But this is the notice to quit that I use, and it's the information at point 4 that is the prescribed information. which firstly confirms that the landlord must get a possession order before the tenant or occupier can be evicted, and that you can't apply for that order until the notice to quit has expired. And secondly, that if the tenant or occupier doesn't know whether they have the right to remain when the notice expires, that they should take legal advice. And also you'll see at 4.2 that it says where you can get legal advice, so Citizens Advice Bureau or a housing aid centre. That is the prescribed information. That is the information that must go in the notice at all times, together with the bit just under 2, which says this does not apply to premises which are let or occupied as specified in section 5(1)(b) of the Protection from Eviction Act. And basically that's referring to excluded tenancies. So they are things like tenancies where the landlord is resident in the property or a family member of the landlord is resident in the property. It relates to occupancy agreements to trespassers, holiday lets, rent-free accommodation, and accommodation for asylum seekers. 9 times out of 10, that's obviously not the type of accommodation you're going to be dealing with, so it won't be an issue. And this notice to quit will be the one that you want to use when you are terminating your tenancies. Now, the other thing I wanted to talk to you about is the savings clause, because I see a lot of notices to quit that don't contain a savings clause. And it's vital that you put one of these in, because it can really help you if you get the date of expiry wrong, or if you have a situation where various dates could be considered the date it should expire. Sometimes there may be some confusion in the tenancy as to the date that the tenancy started or the day that the tenancy started, so it might be difficult to work out when a period runs from and to, all sorts of things. Basically, after you've put the date of expiry, just make sure that you're right, or if later, the next date, open brackets, being at least 4 weeks from service of this notice on which a complete period of your tenancy expires. And you'll note there that I've put in brackets to check the tenancy agreement doesn't differ. It may be that your tenancy says something about the way in which you have to serve the notice to quit, as I've already mentioned. Your starting point before you commence any sort of legal action in relation to this is your tenancy agreement, which hopefully you have got. Obviously, if you haven't, then you may need to start thinking outside the box in terms of trying to work out dates of commencement of tenancy and periods of tenancy. So that's the savings clause. It's a common misconception that notices to quit can be waived or extended, varied. They can't. If somebody serves a valid notice to quit, when that notice to quit expires, the tenancy comes to an end. There's been a number of cases that confirm that. You've got Taylor and Wilden in 1868, you've got Clark and Grant in 1950, and more recently in Fareham, BC, and Miller in 2013. If a notice to quit is served and then essentially ignored, then arguably a new tenancy is created. Having said all that, I appreciate that in practice, sometimes it might be beneficial for you and maybe the tenant to essentially ignore the fact that a notice to quit has been served. And nothing's really likely to turn on that, because neither party is going to bring that to the court's attention as such. But ultimately, if a tenant has served a valid notice to quit and their tenancy has come to an end, you are, within your rights to either seek to evict them or ask them to sign a brand new tenancy for the property if you are willing to allow them to stay there. So in terms of who can terminate, again, this is a common, I get a lot of questions about this, a lot of common misconceptions, but a sole tenant can obviously terminate their own tenancy, and actually you can accept shorter notice from a sole tenant. But as I think I mentioned earlier, it's always a bit risky to take a shorter notice, especially if you're concerned about any occupiers that might be left in the property. And that's because obviously if you are going to have to take possession proceedings, if you've got a valid 4-week notice to quit you can rely on, then that will be much easier than trying to rely on a situation where you've allowed shorter notice from the sole tenant. Joint tenants, and obviously, hopefully you all know that joint tenants can terminate the tenancy for both tenants. A lot of tenants don't often realise that joint tenants, they get very upset when the other tenant terminates the tenancy, but there is nothing that that tenant can do. There's been attempts to take it through the courts and argue that it's a breach of somebody's human rights, but none of that has been successful. A joint tenancy clearly confirms that either tenant can terminate the tenancy for both of them. Anybody who's been appointed by the Court of Protection, a Court of Protection deputy, that's usually done following the application of social services, or maybe a family member where a tenant has mental health has deteriorated and they've got no capacity. Somebody with power of attorney, which basically be a situation where the tenant has thought ahead and has already organised a power of attorney, so that if they lose their mental capacity, they've already appointed somebody who can be their power of attorney and deal with their affairs on their behalf. And just to point out, those affairs must relate to their financial affairs, to the tenant's property and financial affairs. I just bring that up because sometimes you might have power of attorney or be deputised by the Court of Protection, but only in relation to specific things, and you really need to make sure it relates to their property and financial affairs. And then lastly, another person who can terminate a tenancy on behalf of a tenant would be the executor of a tenant if they've been appointed as their executor in the will and the tenant dies, or they've taken steps to go through probate and obtain letters of administration where the tenant has died without a will. So that's who can. It's good to know who can't. So obviously, if a tenant lacks capacity, he can't terminate his own tenancy. A tenant's next of kin or a family member, so regardless of whether they are specified as their next of kin on the tenant's application papers, the person who would be entitled to inherit when they die, unless they've got grants of letters of administration or they've been appointed under the will, they are not going to be able to terminate that tenancy on behalf of your tenant. And I do get a lot of questions about that. A lot of people ring me and say he's died and I can't get anybody in the family to sign the notice to quit. Well, they can't sign it. So it's, you need to remember that if they can't terminate the tenancy, you're the one who's going to have to take steps to do that. Care home also can't. I put these examples up because they are examples that have come to my attention in the past. So nobody from a care home can terminate a tenant's tenancy for you. The social worker can't unless they've been appointed by the Court of Protection, and nobody in the ambulance or the police service can do it either. So the next thing I want to talk to you about is notices to quit following the death of a tenant. So before you can serve a notice to quit, there's two things that you need to make absolutely sure of. The first is that the tenant is definitely deceased, and the second is that no one is entitled to succeed or inherit the tenancy. So in terms of the tenant definitely being deceased, I get a lot of queries from clients asking me about the fact that they can't do anything, they can't terminate the tenancy yet because they haven't got the death certificate. That is also a common misconception. You don't need the death certificate. Obviously, it's very good evidence that somebody has died, but ultimately all you need is evidence that they have died. It's a factual situation, either the tenant has died or they haven't. So as long as you're happy that they have, then you don't actually need the death certificate to start taking steps to terminate their tenancy. But what you do need to make sure of before you serve your notice to quit is also that no one is entitled to succeed or inherit. Now, succession is a hugely complicated area of law that I'm not going to go into detail about today because this is specifically in relation to notices to quit. Needless to say that you need to make sure that if anybody was living in the property at the date that the tenant died or for 12 months before the tenant died, you need to look into whether or not under the terms of the tenancy that person is entitled to succeed or whether your policies and procedures mean that that person is entitled to succeed. You need to get the tenancy out, you need to get your policy out, and you need to comply with both of those things and go through all the steps in those documents, especially in your policy. And only when you've done that and determined that nobody can succeed can you start thinking about serving your notice to quit. And I also do point out here that it's important to bear in mind that any occupiers are not liable for use and occupation at the property for means profit until your notice to quit has expired. Prior to that, it is the deceased estate that is liable for rent until the tenancy terminates. So obviously the quicker you can get through this, through your policy, and make sure nobody's entitled to succeed, or that somebody is entitled to succeed, because then of course if they are and they step into the shoes of the deceased, then they will be liable from the date of death for rent at the property. Whereas otherwise you're going to have to wait for the notice to quit to expire before you can start to think about charging them use and occupation for staying there. So that's succession in a very quick nutshell. And like I said, it's a hugely complicated area, and it's always worth getting some advice if you're not sure about the succession rights under the tenancy and your policy. But the other point to consider is whether the person left in occupation is entitled to inherit the tenancy. Because while they're not entitled to succeed under the tenancy, they may be entitled to inherit it. And the theory goes that where a tenant dies intestate, so without leaving a will, but leaves their next of kin occupying the property. And by next of kin, I mean the person who would be entitled to inherit their estate. So if they are married, that would be their husband or wife. If they're not married, but they have children, then it would be their children. And basically, whoever it is, you need to look up the intestacy rules and see where it is that that person fits under those rules in terms of their ability to inherit the tenancy. But if they leave their next of kin in the property when they die, the argument goes that this creates an equitable tenancy for that person. And this is actually supported by John Luber, QC, in his Defending Possession Proceedings book, but I don't think it's been massively tested in the courts. But where there is a risk of that situation occurring, there is a way to avoid it, and that is to serve what is called a Ground 7 Notice of Seeking Possession. And that deals specifically with this situation. Now, Ground 7 is a mandatory ground. So as long as you serve this notice and everything's been done correctly, then you'll still be able to obtain a possession order in reliance upon that notice. But if you are in any doubt, do seek legal advice about it, and we can help you. I mean, I've got a case at the minute where it had been about 5 months after the date of the tenant, death of the tenant. And the client had unfortunately already confirmed with the occupier that they weren't entitled to succeed. But when I read the tenancy and the policy, it became apparent that actually that person had been entitled to succeed all along, and it had been about 5 months. And sadly, the client had done everything incorrectly, including the service of a notice to quit on that basis. So in terms of the procedure, once you're satisfied that the tenant has died and that nobody's entitled to succeed or inherit, you need to prepare a 4-week notice to quit addressed to the personal representatives of the deceased. And that is how I've written it on the slide, is how it needs to be written. Any deviation from that could well invalidate the notice. Because the Act specifically confirms that that's how it must be written. So it's personal representatives of Joe Bloggs, and then you put deceased in brackets afterwards. And I would address the notice to quit in that way, and also the letter that you send enclosing the notice to quit to the personal representatives. So once you've done that, you also need to make sure that you lodge your notice to quit with the Office of Public Trustee. And I've highlighted that you have to do that at the same time. And that's because of a case called Pavey versus LB Hackney in November 2017, which confirmed that a copy of the notice to quit must be lodged with the Office of Public Trustee before the expiry of the notice to quit. Therefore, to ensure compliance with that, the best thing to do is send everything off at the same time. At the minute, the Office of Public Trustee, the OPT, have confirmed that they want all their applications to be emailed to them since the coronavirus pandemic hit, and want the £40 fee that you have to pay with the application to be paid by backs. Because in addition to the notice to quit, you also have to complete a form NL open brackets 1 close brackets with the notice to quit. It's quite an easy document to fill in. We have it on a software program, but I'm sure you can probably Google the form and find one that you can fill in if you don't already have one within all your paperwork. And I should also confirm that any ground 7 notices of seeking possession also need to be lodged with the Office of Public Trustee. And again, I would just, for the sake of completeness, make sure you do that at the same time. You can send the notice to quit and the notice of seeking possession at the same time and pay £80, but you need to make sure that you do an application in relation to each application. So, sorry, in relation to each document. So you need to do one application for the notice to quit and one application. I'm not sure if I mentioned when I was talking about ground 7 NOS before, that currently, because of the coronavirus pandemic, that notice has to be a 3-month notice. But even prior to the pandemic hitting, it was always a 2-month notice in any event. And then the other thing to bear in mind is that you have to serve a ground 7 notice of seeking possession before 12 months after the date of death. So within 12 months of the date of death, you must make sure you serve it. If it's after 12 months, you lose the right to rely on a ground 7 notice. And as a result, you may have to allow the person in occupation to remain there if they are entitled to inherit the tenancy. So once you've done that, once you've made sure that you've served the personal representatives and lodged the documents with the Office of Public Trustee at the same time, you then need to provide a copy to the occupier or occupiers and comply with what's known as the pre-action protocol. I mean, hopefully before you've even served the notice to quit, you'll have already liaised with your occupiers and dealt with any requests to succeed and notified them in writing of the outcome of that application, and notified them that, you know, because of that, you are going to serve a notice to quit, and that once that notice to quit expires, they'll be liable for use in occupation. But the next thing you have to do, the thing you have to make sure you've done before you issue possession proceedings against that particular occupier, is to comply with the pre-action protocol. So I'll just take you through that. I don't know how clearly you'll be able to see part 3 of the pre-action protocol for possession claims by social landlords, but you can definitely Google this. It's on the Ministry of Justice website. And this basically confirms that before you issue possession relying on mandatory grounds, which possession in reliance upon a notice to quit is, you need to write to the occupier explaining why you're seeking possession and invite them to make written representations within a specified time. So a reasonable amount of time. Usually if I send the notice to quit to the occupier, obviously it's a 4-week notice, so I give them 2 weeks. So while that notice to quit is running, I give them 2 weeks within that time to write to me with any personal circumstances or other matters which they wish to have taken into account before we bring possession proceedings. As the actual pre-action protocol sets out, that you can send that with a copy of the notice to quit, so it wouldn't necessarily delay the issue of proceedings. If written representations are made by the tenant, and to be honest, even if they ring you up and just have a rant down the phone and say they've got some issue, or I think the last one I had, he rang up and he said he was a joint tenant, the other tenant had terminated the tenancy for him, and he rang up and said he had COPD, but he never put any of these he didn't put that in writing. But because he'd rung me up and I'd had that conversation with him, I still wrote back to him to confirm that I understood he had this and the other things that he'd said to me, but that because this was a joint tenancy and his ex-partner had terminated the tenancy for both of them, that we would still be proceeding with possession. As long as you've done that and you've given you reasons why you're continuing, and you do all that, and then what you make sure you do when you bring your claim is that you evidence it. So you obviously confirm the steps you took and the responses you got in a witness statement, or you would confirm it within your particulars of claim when you were preparing your case for court. And I just want to touch upon further considerations, really, because obviously in the current climate, obtaining possession is extremely, I mean, it was always extremely difficult, but now that the coronavirus and the ban on evictions has happened, the backlog at the courts and the extended notices, I mean, it's, you know, it's chaos. So, you know, it is taking longer than it used to get your cases through court and get your actual possession order at the end of the case. So I think it's more important than ever to just think about these further considerations and whether they might be a more proportionate means of dealing with the situation. Because even where your occupier is not entitled to succeed, you need to consider your duties under the Equality Act and whether it would be reasonable, it would be a reasonable adjustment to depart from the terms of the tenancy and your succession policies and essentially grant them a tenancy of the property, grant the occupier a tenancy of the property. Even if the occupier is not disabled, then, or the nature of their disabilities doesn't mean it's going to be harder for them, in fact, to find somewhere else to live. There obviously remains a need for you to act proportionately. And obviously you've got to have regard to your lettings and allocations policies when considering whether or not to grant a tenancy. But you do need to take account of any other factors which may be relevant to the occupier's individual circumstances. So, for example, if the property would be suitable in terms of their ability to pay, so even if they're under occupying, if you undertake a means assessment and they can afford to pay the rent on the property, then it may be worth thinking about giving it to them. I appreciate that that would be a deviation from your lettings and allocations policy, but it may be that that's the more proportionate or reasonable thing to do in the circumstances, especially if you're going to struggle to offer them somewhere else, or if it would be suitable for their needs in any other way, sort of the type and size is suitable. You know, that if they did bid on a property, then that type of property might well be one that they would be entitled to live in. But the other reason I think it's also worth doing that assessment, means assessment, fairly early on, especially if they are asking for a tenancy, is that you might be able to demonstrate that they can't afford to live in the property. If they're under occupying it and the bedroom tax will kick in and they don't get significant amount of benefits, so they don't work, then it may well be that that would be a good angle to explain why they're not going to be able to stay in the property and you're not willing to offer them a tenancy of it. Obviously, any decision to recover possession of the property has to be based on your legitimate aims. And obviously that would include the effective and appropriate allocation of your housing stock in line with your policies and procedures. But like I said, it's just worth thinking about whether if you evict them from this property and they have to go on the waiting list to apply for another one, but they'd still be entitled to that type of property, then it may be a more proportionate means of dealing with your the situation is to grant them a new tenancy. Obviously, the caveat to that would be if there are known persons on your waiting lists who would equally benefit from the property or in greater priority need. You know, if the property is adapted, if the deceased tenant had a disability but the occupier doesn't have a disability, you know, then they shouldn't get to keep that property. They shouldn't be allowed to basically acquire a tenancy through the back door. The point is you need to document the decision you've come to in relation to the property and why. And obviously if the occupier does have some sort of disability that you're aware of, then you do need to complete an Equality Act review and make sure that you've thought about your duties under the Act before you issue possession proceedings against that occupier. Even if the occupier shouldn't be offered a tenancy of that property, you know, I think it's important to try and offer them, if you can, a tenancy of a different property, especially if it's no fault of their own. You know, if you're a joint tenant and the other tenant terminates, you know, you have no control over that. So it's not always going to be fair to just say, you know, you have to leave and we're not going to help you to do anything else. I think, you know, if you can find them suitable alternative accommodation, that's likely to be the best way to deal with the situation. If you can't offer them accommodation yourself, then can you help them to register for accommodation? You know, anything you can think of that you might be able to do to help them, and make sure that you just back up whatever offers of help you've given in writing, so that you can demonstrate to the court that you've made significant effort to try and help this occupier, but the occupier hasn't been in touch or hasn't engaged with the process. It is going to help you. And the other thing to think about is whether to delay bringing possession. So there's been a few cases now where I've served the notice, but then the tenant's got in touch and said he's trying to find somewhere else, the occupier rather. So the tenancy's terminated, there's an occupier in the property, he's trying to leave, but he's really struggling. He's got a support worker, they're trying to help him. He's going to viewings. He's paying the use and occupation charges that have accrued since the tenancy came to an end, and he just needs more time. So I think the thing to do there is to say, that's fine, we can keep it under review, we can let you stay, make sure you pay use and occupation, make sure that you keep applying for properties, demonstrate to us on a regular basis that you are looking for properties, and we will let you stay. I think as long as you do that and you make sure that you confirm all that to them in writing, that you'll review it again in a month, 3 months' time, and that they must pay use and occupation, then you should be okay to leave them in that property. But what I will say is you need to make sure that your letters clearly confirm that that's not going to create a tenancy of the property, and that you won't be accepting rent. You'll only be accepting charges for use and occupation. And like I said, keep it under review. And obviously, if they don't actually move, then you may, unfortunately, have to think about bringing possession proceedings. So I have talked a bit about the tenant notice to quit, to be honest, but I think I'll just cover that in another slide, and also how you deal with it when a tenant appears to have abandoned the property. So, as I've already said, it must be in writing, it must give 4 weeks, it must end on a Sunday or a Monday if that's the last day of the period of the tenancy, which it usually is. Obviously, if they're a sole tenant, you can accept shorter notice, but like I said earlier, think about whether you're going to have any problem with any occupiers who are residing in the property. As I said earlier, the time runs from the date the notice to quit is received. Because of this, I think explaining to a lay tenant about the rules of service is quite difficult. And if the tenant's completing it themselves and posting it to you, the time is going to run from the date you receive it, which might well invalidate it if the date you receive it takes you too far into the 4 weeks from the date that they signed it. So I think if possible, the best way to take a tenant notice to quit from a tenant is for them to complete that information with you, either at the office or at their home. I appreciate in the current circumstances that's quite difficult, but I think the more you can do to make sure that you know the date you're going to receive it on, the better. That's just, you know, it's going to be a lot easier for you, and make sure, you know, because the tenant's not going to be able to work out running it to the last day of a period of the tenancy necessarily, and work out giving enough time for service. Obviously, if you are assisting them to complete the notice to quit, you need to make sure that you're not coercing them. I get a lot of situations where there's been domestic violence, where the victim of domestic violence is advised that she can terminate the tenancy, and then steps might be taken once they've terminated the tenancy to re-grant the tenancy to the victim of the domestic violence. I think, you know, it is at your discretion to do that, but I'd just be wary about taking sides. So I would still take steps to try and help the perpetrator of the domestic violence to find somewhere else to live, especially in situations where essentially it's just their word against the others. If they haven't been convicted for domestic violence and the police aren't saying, you know, you need to help the victim of domestic violence, you need to evict him and let her move back in, then I think ultimately it's not for you to really get involved in that situation. And you must still take those other considerations that I mentioned into account when you're dealing with the remaining tenant, even if you feel that they may be the perpetrator of domestic violence. It's also important to remember, if you are going to rely on a tenant notice to quit, to still make sure that you send a copy of that notice to quit, redacted if necessary, because it might have the outgoing tenant's address on it, new address on it, to the remaining joint tenant, the one who's remained in occupation, and that you still comply with the pre-action protocol, because basically anybody you're writing to that you want to evict in reliance on any notice to quit, whether that's a tenant or a landlord one, you need to make sure that you've complied with the pre-action protocol in the same way. Then, as long as your tenant notice to quit is valid, you can rely on it to bring possession proceedings against the remaining joint tenant, or if they were a sole tenant, against any remaining occupiers. The difficulty becomes if it's not valid. That can be quite difficult, especially if you don't know where the outgoing tenant has gone. But what you can do at that point, if they're a sole tenant at least, is lodge a landlord notice to quit, because they'll no longer be living in the property as their only or principal home, and you'll be in a position to serve that notice to quit on the outgoing tenants. The more difficult situation, if it's not valid and you don't know where the tenant's gone, is if they're joint tenants, because the only person who can rectify that situation is the joint tenant. And if you can't get hold of them to get them to sign a new valid notice to quit, then unfortunately that tenancy is going to remain live. So moving on to abandonment. The first thing you need to establish when you want to serve a notice to quit on somebody because they're no longer living in the property is that they're not living in the property as their only or principal home. That can be quite difficult at times. I currently have a case where the tenant hasn't lived in the property for over 5 years. She moved in for one night, decided there was antisocial behaviour and moved out, and hasn't ever moved back in. However, they have paid their rent. That is, in fact, that's in credit. Their furniture is still in the property, and they are defending the possession proceedings on the basis that they have an intention to return. And that can be quite difficult to counteract. Because if they are engaging in the court proceedings and they're saying they're going to return, then it can be very, very difficult. The simpler cases are the ones where the tenant has vanished off the face of the earth. Where that's happened, you can't find them. Hopefully you've got an abandonment procedure which you can follow in full. If the rent's been stopped, then obviously that's a good indicator. You know, if you've done regular visits, put stickers on the door, and when you go back, those stickers haven't been moved, or really, I mean, sort of across the door, the threshold of it, so that you can see that nobody's opened the door and broken it. Sometimes people just put a bit of sellotape across, things like that. So whatever your policy says about how you are to determine whether somebody has abandoned a property, follow that policy to the letter. And make sure that they have gone. As I've already confirmed, you need to prove that there's no intention to return, and that can be quite difficult. But if you've done all those things and there's been no word from the tenant still, then the chances of you being able to prove that will obviously be better. If all their furniture's gone and they stop paying their rent, the situation will be better. So once you've established that, you can serve your landlord notice to quit on the tenant and provide copies to the occupiers and comply with the pre-action protocol in the same way that you do in relation to notices to quit when somebody dies. The only difference being, of course, that the notice to quit will be addressed to the tenant and not to the personal representatives of the tenant. So if you've done all that, then you will be in a position to bring possession proceedings in reliance upon the notice to quit. However, it's also a good rule of thumb where you are commencing possession against, well, essentially a former tenant, because our position is that the notice to quit has expired, and when it expired, the tenant lost their status as a tenant and is no longer have a live tenancy. But just in case that notice to quit fails, so if they do turn up before the notice to quit expires, or they turn up to possession proceedings when they commence, I think it's also worth serving a notice of seeking possession in the alternative, just in case. So if the notice to quit fails, you can then rely on the notice seeking possession instead. Plus, you can then maybe agree a suspended possession order, which says that they must go and live in the property. And obviously, if they breach that, you can take further steps. But it would mean you'd have to sort of forego reliance upon the notice to quit. The notice of seeking possession should hopefully be able to rely on rent arrears if you've got a rent arrears, so that's grounds 10 and 11. But also it's important to know that you can usually go on ground 12, because there will be some clauses in the tenancy which assist you, such as there'll be a clause in the tenancy that says the tenant must live in the property as their only or principal home. So if they're not doing that, they're in breach of that clause. There might be the other situation that you might arise is that they might be subletting the property to whoever the occupier who's remaining in occupation is. And again, that's usually a breach of a term of the tenancy. So I think that's everything in a nutshell. I've talked a bit longer than I thought. It's 20 to 3 now though, so I am going to have some time for questions, but I'll just deal with the questions that were given before today. And the first question was, what is the real legal backing to serving a notice to quit on an abandonment, and does it actually help avoid illegal eviction claims? Well, it's a really good question, and as I've already alluded to, it can be really, really difficult to get home on a notice to quit in these types of cases, especially if the defendant comes back before the notice expires or defends the possession claim. And I think, just going back to my case before about the 5 years, the biggest problem the client has in that case is the fact that once the notice to quit expired, it took them over a year to actually issue the possession claim. And because of that, after the notice to quit expired, they continued to treat the tenant as a tenant rather than a former tenant on the basis that the notice to quit expired. They continued to take rent, and they also looked at doing a mutual exchange. I mean, obviously they were just trying to resolve the situation, but that conduct can in fact have created a new tenancy. So it's important to make sure that doesn't happen. But as long as you've done everything correctly and you've followed your abandonment procedure, you shouldn't find that you're in any difficulty. But you have to obviously follow your abandonment procedure, get your possession order and get your warrant of possession and get the bailiffs to go around and evict, even though at that point there might be nobody in the property. But as long as you've done all that, a claim for unlawful eviction should be very difficult indeed for the tenant to follow. Obviously, you're in a riskier situation if you just recover the property on expiry of the notice to quit. But I do appreciate that in practice, that happens a lot. And in the current climate where it's very, very difficult to get a possession order, you are going to have to consider on a case-by-case basis whether it's worth taking the risk after you've followed your abandonment procedure and served the notice of just taking the property back. Now, if you do that, the thing to do is to, obviously you will have documented the fact that you've followed your procedure and that you've not heard anything from them for a sustained period of time. But also their biggest claim is likely to be maybe that you've thrown their belongings and things like that. So just make sure you do a full inventory of what's left in the property and take photographs. So just in case they bring a claim to the value of those goods, while it would be frustrating, it's probably going to be cheaper than dealing with some sort of claim from them to just give them the money for whatever it was worth. Because this happens 9 out of 10 times, I mean, I'm talking myself out of the job a little bit, but ultimately you have to take a practical approach to the situation and think about whether, you know, is this going to be the 1 in 10 times that this tenant comes back and says, you know, you've unlawfully evicted me. Obviously it's a risk, but I think it's a risk you just have to think about on a case-by-case basis, because the alternative is going through the whole legal process, which will also cost you money, just to ensure that any future unlawful eviction claim won't succeed. But ultimately, that's the situation, really. I mean, obviously, I have to advise you from a legal point of view, and legally, that's what you should do. The notice to quit itself, when it's in the prescribed form, specifies that you won't actually evict them until you've got the order. So on that basis, you know, you do need to follow the legal procedure. But like I said, in practical terms, I understand why clients might not do that. I hope that deals with the question, but obviously if it doesn't, if you want to email me after this, my email details are on the last slide. And maybe we can have a chat and I can probably talk you through it a bit more. So that was the first question. The second question was, has the notice period on NTQs changed due to COVID-19? And is there any best practice in the current climate? So the Coronavirus Act 2020 did amend notices in relation to Rent Act notices to quit. I'm assuming most of your tenancies are either assured or secure and you don't have many Rent Act tenancies. If you do have any Rent Act tenancies, however, those notices to quit currently need to be 3-month notices to quit. But standard notices to quit in relation to contractual tenancies, so tenancies, the tenancy that's left one sure tenant has lost their assured or secure status, has remained 4 weeks. So no, it hasn't been extended in relation to your average notices to quit. Even prior to the stay, well, even during the stay on possession claims, you were entitled to serve 4-week notices to quit and issue possession, and I did in fact do that. It's just that obviously prior to the 20th of September, those possession claims were issued but then immediately stayed, and now I've had to reactivate them and I'm waiting for court hearing dates. That said, how quickly you're going to get a possession order? There used to be a requirement that possession has to be listed after 4 weeks but before 8 weeks, but now because of coronavirus that requirement has gone and the courts are literally just dealing with things as and when they can get to them, and they probably have a hierarchy and they will be looking at serious antisocial behaviour cases first, then maybe serious rent arrears, and it's just how high up the pecking order these types of cases are really going to get and how long you're going to be waiting. And because of that, those other considerations are more important than ever. And the fastest way to possibly yield an income from those properties may well be to let the occupier, if you're able to, if your policies and procedures allow you to, you know, it may be that that's going to be the preferred method by which to deal with these types of cases, because at least that way somebody will be responsible for rent for that property, rather than you in a sort of limbo land where somebody's liable for use and occupation but they're not paying it, and the only way you can get the property back is to evict them, and it's how long that is going to take at the moment. So I hope that answers that, but again, if anybody needs to email me about that a bit more, then by all means do so. So I'm just checking to see whether I've had any questions, and I can't see that I have. Can that be right? It would seem to be correct. So, oh, hang on, let me just check. Oh, sorry, yeah. I have had a couple of questions. Yeah, the first one was, if you run a notice to quit concurrent with a notice, presumably of seeking possession, do you alter the notice to quit to 3 months? No, you don't do that. Your notice to quit is 4 weeks, and your notice of seeking possession relying on ground 7 is 3 months. But of course, you will have to wait 3 months before you can issue your possession claim. So I think that's it. I can't see any others. I'm amazed. I thought it'll be chewing my ear off. Right. Okay then. Well, given that there's no questions, that's me done. It's obviously been a pleasure to talk to you all, even in this weird setting. I do know that a survey is going to come round after this, so be kind, please, people. And also that I should tell you that we do have some future sessions. On the 20th of October, we have a county line session. On the 3rd of November, we have a session entitled Leaseholder Consultation. And on the 17th of November, we've got Antisocial Behaviour, the New Normal. So that sounds like a lot of fun. So yeah, thank you very much for listening. And that's everything from me. Bye-bye.